Victims of international money laundering schemes are being targeted by Australian police in a bid to seize their funds, in a strategy that could have a disastrous impact on victims, a former officer has warned. Cuckoo smurfing. Schemes launder money by duping innocent parties into being account holders. A series of seemingly legitimate financial transactions known as structured deposits. The schemes have often targeted migrants from Southeast Asian countries who seek to establish a bank account in Australia. Australian Federal Police, who took over proceeds of crime cases from the Commonwealth Director of Public Prosecutions several years ago, use restraining orders under the Proceeds of Crime Act to freeze funds and recover them. But they are increasingly targeting funds from innocent parties of smurfing operations. Former FP officer Chris Douglas, who was heavily involved in financial crime and money laundering operations until he retired in 2013, told Guardian Australia the agency's approach was completely flawed. Ongoing FP action could have a significant impact, if not a disastrous impact, on other victims and upon Australia, particularly if any of the funds have been involved in a cuckoo smurfing scheme are held by a migration agent, education provider or Australian exporter, he said. The FP's approach was thwarted last week in a Western Australian Supreme Court case involving Malaysian couple Ganesh Kalimuthu and Maclean Patricia Michael Das, who had 3M seized after falling victim to a laundering scheme. Justice Jeremy Ellenson found the couple's position is relevantly no different from of a person who sells property to a stranger and is paid by direct debit into his bank account. He struck out the FP's freezing order on the basis that the couple were a third party, not linked to the criminal action. It is not alleged that either respondent was party to any offense in Australia, or knew that the property was the proceeds or the instrument of an offense, Ellenson ruled. Douglas said the FP's pursuit of the couple showed government needed to review the agency's role in forfeiture cases. By targeting Kalimuthu and Das, the FP has gone after what it perceives as being low-hanging fruit, using the very powerful civil forfeiture provisions. That act was never intended to be used against innocent victims of crime, he said. The FP is now seeking to delay other cases it believes it is likely to lose if the Western Australian decision is upheld. In a hearing at the NSW Supreme Court in Sydney on Thursday, the FP sought an urgent order to vacate an upcoming hearing relating to an Indonesian couple who were the victims of a similar laundering scheme. In that case, 6M of their assets were frozen, even though only 3M was believed to be laundered money. As in the West Australian decision, no evidence was offered that the couple were aware of the laundering scheme. During the course of the hearings, the FP Commissioner's Council disclosed there were at least 16 cases, the courts, or awaiting judgment that involved circumstances similar to the West Australian decision. He sought an order to vacate the hearing until the Commissioner, Andrew Colvin, could lodge an appeal against the WA decision, likely to take place next week. It is the Commissioner's position that it is in the public interest to have an appellate ruling on this issue, the Council said. It would be a false economy for the parties to go ahead with the matter. The barrister for the Indonesian couple, Travis Mitchell, told the court, If the FP's application to vacate the hearing was accepted, it would effectively allow the Proceeds of Crime Act to be used as a tool of oppression. The stay application benefits the commissioner only. My clients have 6M of their money restrained, he said. He said it was a false hope that the Western Australian case would resolve everything, because that decision was not necessarily binding on other state courts. The FP declined to comment on its approach to cuckoo smurfing cases but confirmed it would appeal the West Australian decision. The FP shortly intends to seek to appeal this judgment, a spokeswoman said. Contact Paul Farrell securely using the Signal messaging app on +61 457 262 172, or using the Guardian's secure drop server.